Be ready. Start. With reference to the aforementioned transactions and the high seas sales agreements, the case of appellant had been that it had only acted as an agent of the end buyers while filing the bills of entry and the sales of the goods in question to the end buyers, being the sales taking place in the course of import of goods into the territory of India, were eligible for exemption from payment of sales tax by virtue of Section 5(2) of the CST Act. However, in the assessment orders dated 21/2010 and 18/5/2010, the CTO denied the benefit of exemption to the appellant, particularly for the reason that the appellant cleared the goods from the customs after filing the bills of entry and later on raised debits notes showing sales to the end buyers. The CTO held that the goods in question had crossed the customs frontiers of India when the bills of entry were filed by the appellant and the goods were assessed to customs duty, and hence the sales effected by the appellant to the end buyers could not be said to be high sea sales. The appellant felt aggrieved of the orders so passed by the CTO, but instead of availing the statutory remedy of appeal, chose to challenge the same by way of writ petitions in the High Court. These writ petitions have been considered and dismissed by the High Court by way of the impugned judgment and order dated 18/12/2014. The High Court rejected the contention that the appellant had only acted as an agent of the respective end buyers while filing the bills of entry at the port of destination, with the findings inter alia to the effect that customs duty could be assessed only on the importer of goods, that neither in the bill of entry nor in the import general manifest 5 the name of end buyer was reflected as the importer, that it was the appellant alone who had imported the goods, and that the sale by the appellant to the end buyer could have only been effected after the goods were cleared for home consumption. The High Court also rejected the contention that high seas sale to end buyer had occasioned the import of goods into the territory of India. The appellant has challenged the decision of the High Court by way of these appeals on a variety of grounds, as shall be mentioned thereafter. As noticed, the transactions involved in the present matters had been of similar nature. For appropriate dealing with the issues involved, we may take note of the facts relating to the assessment order dated 21/2010 pertaining to the tax period 2005-06 and the assessment order dated 18/5/2010 pertaining to the tax period 2006-07 in necessary details. Assessment order dated 21/2010 relevant facts and background. The appellant M/S Valanki Frameworks is said to be a sole proprietary concern engaged in the business of sales and purchase of logs, timber and wooden battens, and in the course of its business, the appellant also imports timber from other countries. Stop.